for joining us today. My name is Taylor Brewer. I'm here with my wonderful colleague, Julianna Gesiotto. We're here from the California Women's Law Center to give a general introduction on our work and what we do at the California Women's Law Center, but also given in the context of a discussion of the contemporary women's issues here in the US. And kind of delve into our work and the broader work needed to help support women all around the country and especially here in California. So CWLC's mission is to create a more just and equitable society by breaking down barriers and advancing the potential of women and girls through transformative litigation, policy, advocacy, and education. And so those three avenues of advocacy are what we will be discussing today in the context of our main focus areas. But what I also want to touch on here is that CWLC is a support center. And so CWLC as a qualified support center under our state bar grant funding, which is defined under the California Business and Professions Code, is a nonprofit legal service center that provides significant level of legal training, legal technical assistance, or advocacy support without charge to QLSPs on a statewide basis in California. So QLSPs, otherwise known as Qualified Legal Support or Legal Services Projects, means nonprofits, nonprofit projects incorporated and operated exclusively in California that provides a primary purpose and function of legal services without charge to indigent persons, and that has quality control procedures under the state bar. And so that's just a little piece of what we do in the sense that these types of trainings are kind of focused towards these QLSPs and hopefully benefit them in a way that we are best providing legal training and legal technical assistance and advocacy support to those programs throughout California. And so we provide legal trainings most of the time for MCLE credit, like this one today, or others that you will be able to find on the LAAC website. So just in 2024, we've conducted trainings on employment discrimination, review of ethical representation for survivors of abuse, a training kit toolkit for fair housing advocates, and review of the rights for parenting and employees. Thank you. And so all of those trainings fall under CWLC's priority areas of work. And so we'll be going into depth in these four areas, but our four focus areas are women's health and access to reproductive care, Title IX and gender discrimination in school, women's economic security, and violence against women, including sexual assault and domestic violence. So within these categories are several specific issues that impact women's ability to lead healthy and autonomous lives. And so to just give a presentation more, a roadmap of what we'll be discussing is the barriers and injustices that women face within our priority areas. We'll speak to the general context of our specific issues and present the temporary problems women and girls face by discussing the specific projects that our organization takes on and what we have done and are doing to continue in this pursuit of justice and work towards breaking down barriers for women and girls. So with that, I'll hand it off to Juliana, who will start.
Thank you, Taylor. What a great introduction. And thank you everyone for joining. I know some people have continued to trickle in, so welcome. First, we're going to talk about our issue area of women's health. So within this issue area, you can imagine there are a ton of sub issues and a lot that fits into the topic of women's health. We really focus on reproductive health care and abortion access. At CWLC, we think that every woman should have access to accurate, unbiased healthcare information, regardless of age, race, sexual orientation, geographic location, or income level. But unfortunately, many women struggle to get the care they need, and reproductive rights are continually under attack. CWLC is committed to safeguarding women's health, focusing on, like I said, reproductive healthcare access and reproductive justice. Broadly speaking, CWLC supports and advocates for the passage of legislation in California and federally that protects abortion rights. In California, that would be for Californians, visitors to California, and abortion practitioners. So, women have unique healthcare needs throughout their lives, especially during their reproductive years. Everyone deserves the ability to make the choices that are best for them, and access to birth control and safe legal abortion is critical for women to be able to lead healthy lives and make family planning decisions. Of all sexually active women, 99% will use a method of birth control at some point in their lives. 1 in 4 women will have an abortion in her lifetime, and most of those who have abortions are already mothers. More than 4 million people rely on our nation's family planning program, Title X, for their health care. And it's important to note that marginalized women who face multiple forms of oppression at the intersections of their identities face additional oppression in the area of reproductive health care. So while keeping abortion legal is important, it's key to recognize that this choice doesn't actually exist when access is limited. Many women cannot afford care, or they can't travel the distance to get to the nearest abortion provider. Recently, California Women's Law Center has released 2 one-pagers in this space of reproductive health care. They will be available to you if you haven't received already as a written material for this webinar. And they include a one-pager on how abortion is criminalized throughout the United States. So that one discusses how laws in various states work to punish people who have abortions, people who help people get abortions, and abortion providers. The other one-pager is called A Snapshot of Anti-Abortion Policymaking. And that one discusses kind of the anti-abortion policy movement. So it's how anti-abortion advocates are trying to eliminate access to abortion across the country. Okay. And in the wake of the Dobbs decision, CWLC has not only been focusing on the criminalization of reproductive care across the country, but has also been studying and reporting on attacks on reproductive health in California. Although California has strong protections for reproductive health care services, including abortion, our state is not immune to this specific anti-abortion tactic of crisis pregnancy centers. So California Women's Law Center and our partners in the Alliance released a report called Designed to Deceive in 2021, and it exposed how this anti-abortion strategy has been quietly unfolding for decades in states all across the country, including here in California. So crisis pregnancy centers, or CPCs, use deceptive marketing strategies to lure vulnerable pregnant people to their offices, where staff then pushes anti-abortion agendas instead of offering legitimate healthcare resources and information. So our research in this area started in 2019, and every 1 to 2 years since we released our original report, we've been updating our data. Our latest update was released in the spring of this year and can be found on our website. So I kind of want to talk about the deceptive tactics that are used by CPCs and what the data in California currently looks like. So to start off, CPCs portray themselves as legitimate medical facilities in order to trick women into seeking care at the CPCs. So they do this by most of the people there, most of the staff and volunteers will be wearing scrubs. When you enter, you'll enter into a waiting room. You have to fill out paperwork like you would at any clinic. But most of these facilities don't actually have medical staff on site. Most of them do not have doctors on site. 62% claim to offer ultrasound imaging, but very few have sonogram technicians on site. So it's understandable that women who see these CPCs, they know that they can maybe get a free pregnancy test there, and they think that they can get other healthcare access like prenatal care there, would enter a CPC expecting that care, but then they're going to be fed misinformation about abortion to try to dissuade them from receiving abortion care. It's really important to note here that over half of CPCs in California are licensed by the California Department of Public Health. This is an issue that's pretty unique to California, as not every state licenses clinics like this. But in California, you can become a primary care clinic by applying with the CDPH. And it's a pretty simple application process with little oversight. So more than 53% of CPCs in California are licensed. That being said, or continuing on rather, only 36% of licensed clinics in California reference having an on-site doctor on their websites. So there's definitely a discrepancy in the clinics and what they say they offer and what they say that they can do and what they actually can do. So to talk about some of the false medical claims that women hear when they enter these CPCs, I think the big two are abortion pill reversal and post-abortion stress syndrome. So abortion pill reversal is the idea that after a woman takes the first pill in the two abortion medication regimen, they can then take a high dose of progesterone and it will reverse the effects of medication abortion. The thing about APR is that it is not a medically sound practice. There was one study on this regimen, and it was cut short because so many women were hemorrhaging blood. It was too dangerous to continue the study. And yet, many CPCs throughout California promote abortion pill reversal as a valid option for women who have taken the first pill in the abortion regimen. Next, post-abortion stress syndrome, sometimes post-abortion syndrome, sometimes these CPCs will describe the symptoms but not name it. But it's the idea that abortion will lead to a mental illness like PTSD. Now, I think these false medical claims really are just part of the fear-mongering tactic, because what they're telling women who are unexpectedly pregnant is that women who have abortions regret them. And we know that that's generally widely untrue. But by telling these vulnerable women that these are options to them, it's part of the scare tactics that CPCs use. So continuing on those scare tactics, often in the name of education or information sharing, CPCs will provide very graphic depictions of abortion, including using language like the baby was ripped up limb from limb. So it's really just a negative fear mongering we see from CPCs. And then one that I wanted to note, because I think it's a little sneakier, is many CPCs will explain the medication abortion, which is a dose of mifepristone, and then the second medication is misoprostol. And they'll say misoprostol is not FDA approved for use in pregnant women. And that's because misoprostol is usually an ulcer drug and it's an abortifacient. So as an ulcer drug, it's not approved for use in pregnant women because it can cause abortion. That does not mean it is unsafe to take if you are seeking an abortion. And this is just kind of language that they can cite to the Mayo Clinic, but they're not being genuine and honest with the women who are visiting their clinics. So now that we have this information about their tactics, I want to talk about the data that we gathered in 2023 and 2024 about CPCs in California. So there are at least 157 CPCs in California as of earlier this year. I say at least because these organizations are often changing locations, changing names. They might affiliate with larger organizations or de-affiliate. So it can be difficult to track them all down. We found at least 157 over the last year. We collect data using their websites and their social media presence. And 87% of these CPCs offer no prenatal care. 73% of them list no physician on staff And as I mentioned earlier, that's true even of the CPCs that have licenses to operate as primary care clinics. And then 67% of CPCs make false or biased claims on their websites. It's important to note that a lot of these CPCs in California are even receiving public funding. So 7 CPCs in California this past year reported receiving Medi-Cal reimbursements totaling almost $100,000. But we know this number is actually likely higher because there's a lot of misreporting of financial information to CDPH. While every licensed primary care clinic is supposed to submit yearly financial statements, 41% of the licensed CPCs in California failed to submit this financial report at all to the Department of Public Health by the deadline. We also know that across the country, federal funding going towards CPCs has actually been increasing in the last 4 years. And I finally want to highlight the harm that's done by crisis pregnancy centers. During pregnancy, women who go to CPCs often don't realize that they were not receiving legitimate medical care until something goes wrong later in their pregnancy. We had an OBGYN from Northern California reach out to us to discuss the problems that she sees in her own practice of women who didn't realize that they were at a CPC before. And so maybe they had something wrong with their pregnancy that was missed because no one at that crisis pregnancy center actually was qualified to assess that woman's pregnancy. And she's also seen people who were not as far along as they thought they were, because one tactic CPCs use will be to tell women that they're farther along in their pregnancy so that they're less likely to get an abortion. After pregnancy, CPCs provide pretty much no additional health care for the baby or mother. They will provide what they call Earn While You Learn courses. So they'll provide assistance to needy mothers in the form of diapers, wipes, baby clothes, formula, but only after the mother sits through educational courses that the CPC provides. And again, they don't have qualifications to provide these educational services. Many of them are religious organizations, and so the education can be religious based before they're willing to give care to these mothers. And finally, they're collecting data on pregnant women and women seeking abortions. Like I mentioned before, when you arrive at a CPC, you often have to fill out patient paperwork like you would at a real doctor's office. And that data is being collected. And earlier this year, Heartbeat International, which hosts the database for a lot of CPCs across the country, had a massive data breach. So the harms are widespread here. And I now want to talk about the legal landscape in California surrounding crisis pregnancy centers. So it's first really important to talk about the FACT Act. This was passed about 6 or 7 years ago in California, and it said 2 things. First, that if you were a pregnancy center that was licensed, you had to put up a sign in your office that informed women that free abortions can be accessed through Medi-Cal, basically. And the second part of the FACT Act said, if you're not a licensed CPC, all of your communications have to include language that say you're not licensed by the state of California. Now, this was immediately challenged, and that challenge went all the way to the US Supreme Court, where they struck down the FACT Act as a First Amendment violation. It was considered forced government speech. So since the FACT Act was struck down, there have been very few bills introduced in California to address the ongoing problem of crisis pregnancy centers. And this is true even in the wake of Dobbs, where in California, we amazingly passed like 24+ bills into law to protect abortion care and abortion providers, but not one of them directly addressed CPCs. There is litigation ongoing. We were really excited to see last year that Attorney General Rob Bonta did sue 5 CPCs and their parent companies under unfair competition laws for their promoting and performing abortion pill reversal. And that's wonderful. And we were really excited to learn from the AG's office about that suit. But it is important to note that that is a really small issue area, and it's only going after 5 CPCs. So even if they're no longer allowed to promote abortion pill reversal, that doesn't address the underlying problem we have of crisis pregnancy centers throughout the state. In the education realm, Rob Bonta also put out a consumer alert warning women about CPCs to try to kind of prevent women from even going to them in the first place, but it's still something that's not super widely known. So at California Women's Law Center, like I've mentioned, we periodically every year or two update our research and release updated data and reports in our Design to Deceive report and their subsequent updates. And then we also do educational speaking engagements. There was a documentary that came out this year about CPCs called Preconceived, and we hosted a screening and spoke at multiple other screenings to educate people about this. And then in 2022, Taylor actually went and supported an LA City ordinance that regulated the advertising language of crisis pregnancy centers to make sure people knew that they were crisis pregnancy centers rather than legitimate healthcare facilities. So with all of that being said about our work on CPCs and in the repro realm, I want to switch over and start talking about gender discrimination and Title IX. So one way we at CWLC combat inequity is by enforcing Title IX, the 1972 federal law that prohibits educational institutions from discriminating based on sex. CWLC focuses on Title IX enforcement in 2 main areas: the treatment of pregnant and parenting students and athletic equity. So to start, Title IX protects pregnant and parenting students from discrimination. However, many young women who become pregnant are routinely stigmatized, marginalized, and coerced into dropping out of classes and attending substandard schools. Laws in California strengthen moms' abilities to breastfeed and pump at work and in school, and protects parents beyond even federal law requirements. So periodically, to help enforce the requirements for pregnant and parenting students, CWLC and our partners like ACLU SoCal and Breastfeed LA release what we call report cards on the state of lactation accommodations in Los Angeles County schools and in statewide school districts. So we gather information from each district's websites to answer these following questions about pregnancy accommodations and their availability at these schools. First, is there an easily identifiable Title IX coordinator? Second, does the district have their board policies online? Third, does the district have lactation accommodation policy for employees? Fourth, does it have a pregnant and parenting student policy? And fifth, does it have a lactation accommodation policy for students? So the idea is if a school district meets all 5 of these criteria, they get an A on their report card. And schools that have lower grades will actually reach out to those districts and say like, hey, you're missing these criteria that would help your pregnant and parenting students and help you meet the Title IX and California legal requirements for their accommodations. Since we started doing this, the numbers the grades have really gone up. So to give you all some examples, 93% of school districts in the most recent update, which was last year, had lactation accommodation policies for employees, and that's up from 33% when we first did this in 2015. Now, 100% of school districts have an easily identifiable Title IX coordinator. Only 23% had that in 2015. Now, 79% of school districts in LA have lactation accommodation policies for students, up from 17% in 2015. And finally, of the 81 school districts graded, 62 received an A. Only 1 received an A the first time we did this in 2015. So this work is really exciting to actually be able to compare and see the difference that we're making for pregnant and parenting students. And then the other thing we do in this sphere is host trainings on these issues. And you can see on your screen, I won't list them all out, but pretty much every year we host some sort of training on the rights of lactating students, pregnant and parenting students, and employees. Next, Title IX is probably most well known for ensuring that girls have access to equal athletic opportunities to boys. But despite this legal guarantee that has been in place for over 50 years, many female students still do not have equal access or equal treatment in sports. So the majority of our impact litigation actually comes from our work in Title IX athletics enforcement in the high school level. We are one of the few, if not the only organization that's currently doing this work at the high school level in California. So I wanted to start with some insight into why we believe, or why we know that sports in high school are so important for girls. They have academic, health, and career benefits in school and throughout the lifetime. So girls who play sports in school have higher grades and test scores, fewer disciplinary issues, better attendance, and an increased graduation rate compared to girls who didn't play sports. They have higher health benefits when they're in school, so higher levels of confidence, physical competence, esteem. They're less likely to smoke cigarettes, use drugs, engage in high-risk behaviors, and they're actually these health outcomes exist throughout the lifetime. So even if you stop playing sports, these health outcomes are still visible. You're less likely to develop heart disease, diabetes, osteoporosis, breast cancer, Alzheimer's, and other health problems later on in life if you had played high school sports. And finally, the career benefits. Girls who play sports are more likely to attend and graduate college, more likely to participate in the workforce and earn higher wages. And there was a survey of 400 female executives across 4 countries, and it found that 94% of these executives were former athletes, and that wages for athletes were actually 7% higher than wages for non-athletes. So clearly, it's important that girls can access sports when they're in school. So let's talk about the requirements that Title IX mandates in this area. First, it requires equal participation opportunities for girls and boys. That means that if a school district, for example, is 48% female, their 48% of the opportunities to play sports should be going to girls. And then secondly, it requires the equal treatment and benefits for girls and boys athletes. So as you can see on your screen, here are some factors that we consider. Are there equal equipment and supplies, games and practice times, travel, coaching, etc. A really big one here is the equipment and supplies and the facilities and maintenance. We'll see that boys sports like tackle football and baseball have beautiful stadiums that are well maintained and groomed. They have, batting cages and beautiful dugouts and turf football fields. And then you look at the girls sports and they don't get that same treatment. They have crappier fields that are not maintained as well by the school. They have outdated features, uncovered dugouts, things like that. And it's really just this disparity at the most fundamental level that we try to address in our litigation. Now, it's also important to note in this current legal landscape with the Supreme Court, what it is now, that a lot of Title IX law is based on policy interpretations from the Department of Education. And now with Chevron deference no longer, a thing, it's kind of unclear the future of these policy interpretations at this time. But for now, we're still relying on them. AB 2404, or the Fair Play Act, is a California law that was passed back in 2004 and went into effect the following year. And it was created to mirror the mandates of Title IX athletics law. So I'm not going to go super into detail about it because it's literally like equal opportunities and equal treatment and benefits. It was designed to modeled after Title IX. So no litigation has ever been filed under this act. I don't think many municipalities, parks and rec departments know that the law exists, but CWLC and our partners have brought demand letters. We have claimants under the Fair Play Act, and we've reached pre-litigation settlement in these matters. So here is a list of some of our Title IX athletics and Fair Play Act litigation. We have a few more upcoming as well, which is pretty exciting. And I have highlighted here the Sweetwater case. That came to us in 2007, actually, but it was initiated in 2005, and we tried to work with the district at first, but when we couldn't, it led to litigation in 2007. Our clients were softball players, and they came to us about discrepancies between the softball and baseball fields and the way the teams were treated at their school. And they tried even before coming for legal counsel, their coach went to their school district and tried to remedy these issues, and the coach was actually fired. So along with our partners at Legal Aid at Work and Manat, Phelps, and Phillips, we filed a class action lawsuit in 2007. We persisted on this case for 7 years. It went through the district court and it ended up going to the Ninth Circuit Court of Appeals in 2014. And the Court of Appeals affirmed the lower court's rulings in their entirety, that the school district had violated Title IX by failing to provide plaintiffs with equal athletic opportunities, equal treatment and benefits, and that the school district had unlawfully retaliated against the students for filing the lawsuit when they fired their coach. This landmark case was the first to classify firing a coach as retaliation, not against the coach, but against the girls themselves, because they had an experienced coach who they trusted and who was leading their team. And when that coach complained on their behalf and was fired, that hurt the team and it injured the girls. And what's kind of insane about this is that Sweetwater is just now in their final year of settlement monitoring. So a case that came to us in 2005 is just winding down almost 20 years later. So with that, I want to share with you guys a video from the named plaintiff in this case. I'm hoping you all can hear it. Someone tell me if you can't.
We had a coach who was a parent that wanted to help us build more on our field, to help build cinder block dugouts and build an outfield fence, because we didn't have those things. And so when the head coach went to administration to ask, these girls have a right to have something better, the admin had turned to the head coach and said, we can let you go at any given time without any reason or cause. The parent coach went and found an article about Alhambra's case and brought it to the team and said, hey, girls, you girls have rights. And if you want, we can contact legal counsel. And that's how we got started. The parent contacted the California Women's Law Center. Here I'm thinking that, oh, they're going to find out that they're wrong and they're going to settle. And when they denied, I was surprised and found out that we were going to court. I was nervous to be the lead plaintiff. Both my parents went to school there. Ollier versus Sweetwater is pretty huge. Everybody knows who you are. But at the same time, it felt powerful to know that we could say something. Gosh, I remember going through those depositions, being so nervous, our lawyers just sitting there with us, being strong, helping us through. Getting the news that we won was absolutely amazing. Just being able to feel that joy and accomplishment in all those years of work and knowing that we were right and to know that that change was going to be made. It was absolutely going to be made. California Women's Law Center has done so much in helping me create my own voice and helping me feel that I can help others. It has completely changed my life.
Right, and on that uplifting note, I'm going to turn it over to Taylor.
Great. Thank you so much, Juliana. So now moving on to our second set of focus areas here. Here at CWLC, we understand the importance of economic security as it's central to women's struggle for equality. Financial instability underpins and exacerbates many challenges that women face, financial dependence, adds pressure to stay in abusive relationships. Workplace harassment goes unreported by someone desperate to keep their job. And unintended pregnancy strains a family's resources, and older women suffer from a lifetime of wage inequality. Moving on. So we here at CWLC acknowledge equal pay days. So the most recent one was August 7th, which was Mom's Equal Pay Day, which marks the day that the average mother must work into 2024 to make what the average father did in 2023. Moms working full-time year-round are paid 71 cents, and all earning mothers, so including part-time and seasonal workers, are paid 63 cents for every dollar paid to dads. So mothers working full-time and year-round make only 71 cents for every dollar paid to a full-time year-round working fathers. And this wage gap robs mothers working full-time and year-round of about $20,000 a year, an amount that could pay for 7 months of rent, 7 months of family groceries, or 5 months of childcare. And so when we look broadly in the next slide here at the equal pay, the wage gap, women in the U.S. who work full-time year-round are typically paid, all women, not just mothers, are typically paid around 83 cents for every dollar paid to their male counterparts. So this gap in earnings translate to about $10,000 less per year in median earnings. And even with the same background, education, skills, same hours in the same jobs, a gender wage gap persists, and it's even widened for people of color. So inequity against women in the workplace often begins with pregnancy and parenting discrimination. The wage gap disproportionately impacts pregnant and postpartum working women of color, who often face devastating consequences when they're forced to choose between their job and health. Family caregiving responsibilities bring different pressures for working women and men, and research has shown that being a mother can reduce a woman's earnings, while fatherhood can actually increase a man's earnings. So CWLC leverages our legislative advocacy in this space to push for public policies that give all women and mothers the same freedom and opportunities to give rise to their careers, something that fathers have long been able to count on, thanks to the unpaid care and work performed by women. These policies include the Federal Paycheck Fairness Act, which would protect workers from retaliation for discussing pay, banning the use of prior salary history, and codifying pay data collection. The Healthy Families Act, which would provide employees the right to earn job protected time off when they or their loved ones are sick, hurt, or getting medical care, as well as needs in connection with sexual or domestic violence. And the Family Act, to ensure that every worker, no matter the size of their employer, or if they are self-employed or part-time, has access to paid leave for care for a family member following a serious medical event. So economic insecurity largely impacts women in multiple ways. For example, as I said prior, what we find with elderly women is that there is a compounding of the discrimination at a later age. So women typically make less than men, which generates a less available income and savings in retirement compared to men. So a Black woman's lifetime loss of earnings is totaled to nearly $1 million. For Latina women, it looks more like $1.1 million. At the peak of the pandemic recession, so spring of 2020, older women had higher rates of unemployment than older men across all races and ethnicities, with the highest rates among Latinas. unemployment rates have since declined more slowly for older Black women. And so moving into that, what we've also seen is that housing loss and insecurity is frequently a reality of economic insecurity. And so the graphic that we have here is a point in time estimate for LA County and LA City when it comes to the homeless count that occurred earlier this year. And so statewide, 49% of women are rent burdened compared to 43% of men, according to this report. 25% of California women are severely rent burdened, spending more than half of their income on housing costs compared to 20% of men. In Los Angeles County, the numbers are worse, where 53% of women are considered rent burdened. 1 in 3 Black women who spend more than half their income on housing in Los Angeles area. And then there are a slew of other factors that have contributed to the problem. According to this report, including lower pay than men, discrimination in the housing market, domestic violence, and the time suck of caregiving duties. And so here at CWLC, we work towards homelessness prevention through our housing clinics. So we provide a bi-weekly housing clinic where many of our attendees are facing issues brought on by the or that were heightened by the pandemic, including threatened or actual eviction, inability to pay rent, uninhabitable living conditions, harassment, and other unfair illegal tactics used by landlords. And so we provide counseling, general information through these housing clinics to provide anyone throughout the state of California. Largely our attendees are within LA County and LA City. We provide them with an abundance of information regarding habitability issues, and then the rapid process of the basic eviction process in California and in LA City and LA County. And so we often use, multiple advocacy avenues. And so while our housing clinic largely is more boots on the ground, working with individuals who are experiencing these issues and providing educational resources, we also work in impact litigation cases, including our most recent Green et al. V. Skid Row Housing Trust, which just culminated at the beginning of this year. So this impact litigation case, we represented tenants who lived in horrifying and substandard conditions. We assisted these residents to advocate on their behalf for safe housing and prevent substandard conditions for individuals who largely had previously been experiencing homelessness. So we aim to ensure affordable housing is not only available, but also clean and safe for all tenants, an aspect that we believe is paramount in our efforts to stop eviction and displacement. We also provide trainings, as we've referenced before, with our partners at LAAC. There are trainings on their website, including housing barriers, training, re-eviction, and administrative complaints, know your rights for housing laws protecting domestic violence survivors, and equal pay laws, what you need to know. And so moving forward, as you can imagine, economic security is a rather broad issue area, and oftentimes our issue areas intersect. So especially when it comes to violence against women as an issue area, many factors contribute to the prevalence of violence and harassment, and much of CWLC's work helps to combat these injustices. Most directly, CWLC advocates for and protects the safety of women and girls by focusing on intimate partner violence and campus sexual assault and harassment. But we also see, largely in my work, that affordable housing and housing, how homelessness prevention often also intersects with violence against women issue area. And so to speak broadly, domestic violence, otherwise known as intimate partner violence, is the willful intimidation, physical assault, battery, sexual assault, and other abusive behaviors as a part of a systemic pattern of power and control perpetrated by one intimate partner against another. And it includes physical violence, sexual violence, threats, and emotional abuse. The frequency and severity of domestic violence can vary dramatically. So 1 in 3 women and 1 in 4 men have experienced some form of physical violence by an intimate partner. And in a single day, 81% of California domestic violence shelters served around 5,000 adults and children, and 1,200 requests for services went unmet due to lack of resources. And so to eliminate violence against all women and girls, we have to address how violence differs between groups of women, because the violence women and girls experience isn't just based on their gender. So we have found that 44% of lesbian women experience intimate partner violence compared to 35% of heterosexual women. Women and girls with disabilities are 2 to 4 times more likely to experience domestic violence than women without disabilities. And so this slide provides some statistical context showing the intersection of housing instability as well with domestic violence. So housing insecurity and domestic violence are fundamentally linked. Neither can be solved without addressing the other. And so housing insecurity is a primary reason why survivors across genders and age ranges stay in abusive relationships, and why children continue to be exposed to domestic violence, a key risk factor for future perpetration and chronic health conditions. Unstable housing and homelessness make survivors and children vulnerable to new forms of violence, creating an even greater risk that the cycle of violence will continue into new generations. So what is CWLC doing? We work with other pro bono attorneys and have co-authored amicus briefs and joined additional briefs that contributed to important wins for survivors of sexual and domestic violence. So CWLC has successfully supported the Hatley v. Southard in amicus support and publication, where the court found a pattern of coercive control, including financial control allegations, if true, would meet the broad DVPA definition of abuse, especially as amended by the 2020 Senate Bill 1141, which clarified that the DVPA abuse includes, among other things, coercive control. CWLC was a co-sponsor of Senate Bill 813, signed into law in 2016, the Justice for Victims Act, authored by Senator Connie Leyva, which was a landmark bipartisan bill, which eliminated the arbitrary statute of limitations for rape and related felony sex crimes in California. Now, regardless of when a rape or sexual assault is reported or discovered, victims of sexual crimes can seek justice in criminal courts. And new law provides a path to legal justice for victims and puts perpetrators on notice that they will be held accountable. And then moving forward, the last kind of avenue of advocacy that we work on in this space is, again, our training. So an example of how our work is informed by how our issues overlap is, again, our housing and DVRO training specifically. Our community partners reached out to discuss how their clients, who were largely survivors of DV, would be interested in these types of trainings regarding their housing rights as well. So in that training, we review the intersection between housing and DV issues, including the laws that are depicted in the next slide. And so we cover state laws, including the DVPA under the Family Code, and which broadly provides that survivors avenues to remove abusers from their home and require their abusers to continue to pay the abuser's portion of rent or mortgage. We also move into federal laws as well. Going into the Violence Against Women Act, which protects survivors living in certain subsidized housing by making it illegal to deny housing to survivors of domestic violence, sexual assault, dating violence, and stalking, and terminating housing of these survivors, otherwise penalizing them because they are survivors. And broadly, we discuss the Federal Fair Housing Act, but also FEHA here in California, which provides protections against housing discrimination for people of the certain classes, so race, color, religion, national origin, sex, disability, familial status, including veterans, military status, genetic information, a source of income in California specifically. And so with that, I'll hand it back to Julianna.
Yeah, thanks, Taylor. If anyone watching has any questions, if you want to start putting those in the Q&A now, while I talk about what's next for CWLC. So we have a few upcoming reports that we are going to be excited to share. One is a white paper about maternal mortality policy in California with some suggestions for how we can kind of grow our maternal mortality policy to prevent such a horrible endemic in the States. And then there's also a legal analysis of abortion shield laws, because in the wake of Dobbs, so many shield laws have been passed by pro-abortion states like California. We were kind of looking into the future and worrying about potential legal challenges to these shield laws. So we have a legal analysis of those coming out. And then we're also going to have some other one-pager resources about those topics. I also wanted to note that August is National Breastfeeding Month. We're joining Breastfeed LA for their Know Your Rights training seminars they have at the end of the month. We'll be helping to assist on one of those seminars. The next housing clinic, like Taylor said, it happens twice a month, and the next one is actually in 2 days. And then just in general, keep your eye out for upcoming legal trainings. We generally host them monthly, but that's kind of give and take as we can plan them and get them together. So keep an eye out for those. And with that all being said, please drop any questions you have. We don't see any yet.
Yes.
Let's see. Okay.
We'll wait on trainings, but I want to thank you all for joining us or not trainings. We'll wait on questions, but I want to, again, thank you all for joining us today and learning more about our organization and the issues that we work on and women in California nationally face today. We have one.
Yeah.
Go ahead. Yeah.
Okay. Yeah. We have one question. Someone says, I'm in-house counsel. What can I do to help CWLC?
Yeah, so there are a few ways that we work with outside counsel with our pro bono cases. When we take on impact litigation cases, we ask for co-counsel and other pro bono assistance. We've also used pro bono assistance when it comes to reviewing some of our research and documents before they go out to the broader public to review to see if there are any notes to be had and made corrections to be made before they go out to a broader community.
And I would also like to add that when we do all of these legal trainings, we usually do them with partners. So if I'm not sure in-house counsel what specifically you do, but we love to work with people who are experts in, a certain area of the law to put on trainings together that would be helpful to qualified legal service providers.
Yes, definitely. Recently, one that Julianna just put on was about employment law and how to make sure that your organization is working well under employment law, especially for women in the workforce.
Yeah.
Great. Well, thank you so much for your question. Again, thank you all for joining us today. Open for questions for the next 5 minutes, but again, thank you all.
And our contact info is on the screen for CWLC. If you, work for a QLSP and need technical assistance, need a resource that you can access and want help with that, please do reach out to us. If you want to volunteer or are interested in helping with the training, please feel free to reach out to us. We would love to meet you and work with you. So thank you so much. And with no further questions, I think we can hand it back to LAAC.
Thank you for joining us for today's webinar. This webinar was hosted by the Legal Aid Association of California, also known as LAAC. We are the membership organization for California's civil legal aid nonprofits. Our job is to advocate in the legislature, in the courts, and with the State Bar of California on behalf of the community of nonprofits that serve low-income Californians. In addition to our online and in-person trainings, LAAC provides coordination and advocacy for increased funding to support organizations like yours. Thank you.